Legal writing is a type of technical writing used by lawyers, judges, legislators, and others in law to express legal analysis and legal rights and duties. Legal writing in practice is used to advocate for or to express the resolution of a client's legal matter. Distinguishing features. Authority legal writing places heavy reliance on authority. In most legal writing, the writer must back up assertions and statements with citations to authority. This is accomplished by a unique and complicated citation system, unlike that used in any other genre of writing. The standard methods for American legal citation are defined by two competing rule books, the ALWD Citation Manual, a professional system of citation, and the Blue Book, a uniform system of citation. Different methods may be used in other countries. Precedent legal writing values precedent, as distinct from authority. Precedent means the way things have been done before. For example, a lawyer who must prepare a contract and who has prepared a similar contract before will often reuse, with limited changes, the old contract for the new occasion. Or a lawyer who has filed a successful motion to dismiss a lawsuit may use the same or a very similar form of motion again in another case, and so on. Many lawyers use and reuse written documents in this way and call these reusable documents templates or, less commonly, forms. Vocabulary legal writing extensively uses technical terminology that can be categorized in four ways: specialized words and phrases unique to law, for example, tort, fee simple, and novation. Quotidian words having different meanings in law, for example, action, consideration, execute, and party. Archaic vocabulary legal writing employs many old words and phrases that were formerly quotidian language, but today exist mostly or only in law, dating from the 16th century. English examples are herein, hereto, hereby, heretofore, herewith, whereby, and wherefore. Said and such. Loan words and phrases from other languages. In English, this includes terms derived from French and Latin and are not italicized as English legal language, as would be foreign words in mainstream English writing. Formality these features tend to make legal writing formal. This formality can take the form of long sentences, complex constructions, archaic and hyperformal vocabulary, and a focus on content to the exclusion of reader needs. Some of this formality in legal writing is necessary and desirable, given the importance of some legal documents and the seriousness of the circumstances in which some legal documents are used. Yet not all formality in legal writing is justified. To the extent that formality produces opacity and imprecision, it is undesirable. To the extent that formality hinders reader comprehension, it is less desirable. In particular, when legal content must be conveyed to non-lawyers, formality should give way to clear communication. What is crucial in setting the level of formality in any legal document is assessing the needs and expectations of the audience. For example, an appellate brief to the highest court in your jurisdiction calls for a formal style. This shows proper respect for the court and for the legal matter at issue. An inter-office legal memorandum to a supervisor can probably be less formal, though not colloquial, because it is an in-house decision-making tool, not a court document. And an email message to a friend and client, updating the status of a legal matter, is appropriately informal. Transaction documents legal drafting fall on a similar continuum. A 150-page merger agreement between two large corporations, in which both sides are represented by counsel, will be highly formal and should also be accurate, precise, and airtight. A commercial lease for a small company using a small office space will likely be much shorter and will require less complexity, but may still be somewhat formal. But a proxy statement allowing the members of a neighborhood association to designate their voting preferences for the next board meeting ought to be as plain as can be. If informality aids that goal, it is justified. Many U.S. law schools teach legal writing in a way that acknowledges the technical complexity inherent in law and the justified formality that complexity often requires, but with an emphasis on clarity, simplicity, and directness. yet many practicing lawyers, busy as they are with deadlines and heavy workloads, often resort to a template-based, outdated, hyper-formal writing style in both analytical and transactional documents. This is understandable, but it sometimes unfortunately perpetuates an unnecessarily formal legal writing style. Categories of legal writing. Legal writing is of two broad categories: legal analysis and legal drafting. Legal analysis is twofold: predictive analysis, and persuasive analysis. In the United States, in most law schools students must learn legal writing. The courses focus on predictive analysis, that is, an outcome predicting memorandum of a given action for the attorney's client. And persuasive analysis, for example, motions and briefs. Although not as widely taught in law schools, legal drafting courses exist. Other types of legal writing concentrate upon writing appeals or on interdisciplinary aspects of persuasion. Predictive legal analysis. The legal memorandum is the most common type of predictive legal analysis. It may include the client letter or legal opinion. The legal memorandum predicts the outcome of a legal question by analyzing the authorities governing the question and the relevant facts that gave rise to the legal question. It explains and applies the authorities in predicting an outcome, and ends with advice and recommendations. The legal memorandum also serves as record of the research done for a given legal question. Traditionally, and to meet the legal reader's expectations, it is formally organized and written. Persuasive legal analysis. The persuasive document, a motion or a brief, attempts to persuade a deciding authority to favorably decide the dispute for the author's client. Motions and briefs are usually submitted to judges, but also to mediators, arbitrators, and others. In addition, a persuasive letter may attempt to persuade the dispute's opposing party. Persuasive writing is the most rhetorically stylized. So although a brief states the legal issues, describes authorities, and applies authorities to the question as does a memorandum the brief's application portion is framed as an argument. The author argues for one approach to resolving the legal matter and does not present a neutral analysis. Legal drafting. Legal drafting creates binding, legal text. It includes enacted law like statutes, rules, and regulations. Contracts. Personal legal documents like wills and trusts. And public legal documents like notices and instructions. Legal drafting requires no legal authority citation, and generally is written without a stylized voice. Legal writing in academia. Mercer University School of Law is home to the Legal Writing Institute, the world's largest organization devoted to improved legal writing. The Institute's 2,100 members represent attorneys, judges, and legal writing professors in the United States, Canada, Europe, Asia, Australia, and New Zealand. Plagiarism. In writing an objective analysis or a persuasive document, lawyers write under the same plagiarism rules applicable to most writers. Legal memoranda and briefs must properly attribute quotations and source authorities. Yet, within a law office, a lawyer might borrow from other lawyers' texts without attribution, in using a well-phrased, successful argument made in a previous brief. Plagiarism is strictly prohibited in academic work, especially in law review articles, seminar papers, and similar writings intended to reflect the author's original thoughts. Legal drafting is different. Unlike in most other legal writing categories, plagiarism is accepted, because of the high value of precedent. As noted, lawyers extensively use formats in drafting documents. Borrowing from previous documents is common. A good lawyer may frequently copy, verbatim, well-written clauses from a contract, a will, or a statute to serve his or her client's legal interests. Legalese. Legalese is an English term first used in 1914 for legal writing that is very difficult for laymen to read and understand, the implication being that this abstruseness is deliberate for excluding the legally untrained and to justify high fees. Legalese, as a term, has been adopted in other languages. Legalese is characterized by long sentences, many modifying clauses, complex vocabulary, high abstraction, and insensitivity to the layman's need to understand the document's gist. Legalese arises most commonly in legal drafting, yet appears in both types of legal analysis. Today, the plain language movement in legal writing is progressing and experts are busy trying to demystify legalese. Some important points in the debate of legalese v. plain language as the continued standard for legal writing include public comprehensibility perhaps most obviously, legalese suffers from being less comprehensible to the general public than plain English, which can be particularly important in both private and public matters. Resistance to ambiguity legalese may be particularly resistant to misinterpretation, be it incidental or deliberate, for two reasons. Its long history of use provides a similarly extensive background of precedent tied to the language. This precedent, as discussed above, will be a strong determinant of how documents written in legalese will be interpreted. The legalese language itself may be more precise when compared to plain English, having arisen from a need for such precision, among other things. Joseph Kimball, a modern plain English expert and advocate, rejects the claim that legalese is less ambiguous in the great myth that plain language is not precise. Kimball says legalese often contains so many convoluted constructions and circumlocutions that it is more ambiguous than plain English. Coverage of contingencies legal writing faces a trade-off in attempting to cover all possible contingencies while remaining reasonably brief. Legalese is characterized by a shift in priority towards the former of these concerns. For example, legalese commonly uses doublets and triplets of words which may appear redundant or unnecessary to laymen, but to a lawyer might reflect an important reference to distinct legal concepts. Plain English advocates suggest that no document can possibly cover every contingency, and that lawyers should not attempt to encompass every contingency they can foresee. Rather, lawyers should only draft for the known, possible, reasonably expected contingencies. See Howard Darmstadter, Hereof, Thereof, and Everywhere of, A Contrarian Guide to Legal Drafting 34. Expectation preference regardless of its objective merits or demerits when compared to plain English, legalese has a clear importance as a professional norm. As such, lawyers, judges, and clients may expect and prefer it, although no client or judge has ever actually expressed such a preference publicly. But a study conducted by Joseph Kimball has expressly revealed the preference of judges and lawyers for plain language alternatives. See also, business speak, legal English, plain language, list of plain English words and phrases, scribes, the American Society of Legal Writers, Walter F. George School of Law. Notes. References and further reading, International Legal English, written by Amy Croy-Lindner and Translegal, is a coursebook for Cambridge SOLA Euro Unregistered Trademark S International Legal English Certificate. Brian Garner, a Euro Unregistered Trademark S Dictionary of Modern Legal Usage, is regarded as an authoritative guide to legal language, and is aimed at the practicing lawyer. Peter Butt and Richard Castley, a Euro Unregistered Trademark S Modern Legal Drafting, is a reference book aimed at the practicing lawyer. Legal English by Rupert Hay and published by Routledge. B. M. Gandhi's Legal Language, Legal Writing and General English, ISBN 978-94351451228, New ELS, English for Law Students, written by Maria Fradosio, is a coursebook for Italian university students. The Scribes Journal of Legal Writing, created by Scribes, the American Society of Legal Writers. The Oxford Handbook of Legal Correspondence by Rupert Hay and published by Oxford University Press. For a humorous perspective on legal writing, see Daniel O. White's Still the Official Lawyer's Handbook, Chapter 13, pages 171 to 176, especially its notorious riff on how a lawyer might edit, and torture, the phrase "the sky is blue." Similarly, see Professor Fred Riddell's Goodbye to Law Reviews, whose opening lines contain the classic statement of the problem: there are two things wrong with almost all legal writing. One is its style. The other is its content. Pages 241. External links, Exercises for Legal Writers 2, Wordiness, Exercises for legal writers: I. Active and passive sentences and writing with verbs.